Good afternoon, everyone. Thank you for joining us. I'm Teresa Rusnick. I'm presenting today with my colleague, Carrie Langen. We are, of course, talking to you about the guidance that came out for New York State paid sick leave as of October 20th. I know that this has been something that's been long awaited for most of us, if not all of us. Spoiler alert, it doesn't actually do as much as we would have liked it to do, but Carrie and I are going to go through and talk about the implications of that guidance. So this is Carrie and I. Feel free to contact either of us after the presentation. This is how we can be reached. For purposes of the presentation, as usual, please put your questions in the chat function. We will do our best to get to those either midway throughout the presentation or at the end. And I thank you to everyone that did submit your questions ahead of time. As you'll see at the end, Carrie and I are going to go through and answer some of the ones that we received prior to today's webinar. So, on October 20th, 2020, New York State DOL released its guidance on paid sick leave, which we had been waiting for pretty much since the statute was announced back in April 2020. The guidance does answer some questions and give us some parameters to work with, especially as we go towards policy drafting. So we're going to talk about that, but we're also going to talk about the number of questions that the guidance leaves unanswered, and Carrie's going to follow up with some potential news from DOL about when we might get more guidance or regulations on this topic. So one of the remaining questions, and I know this is a big one for many employers, is how to count employees for purposes of finding out employer size for whether or not you need to offer 40 hours or 56 hours and whether paid sick leave needs to be, paid or unpaid. So I know that that's been a question that's, still, to my knowledge, unanswered by the guidance, and hopefully something that DOL will address in regulations prior to January 1. But the guidance does provide that if an employer has multiple locations within New York State, employees at all locations are counted towards the employer size. And that makes sense, right? So a company, for example, with 3 employees in Utica, 80 employees in Syracuse, and 30 employees in Buffalo would need to provide all employees with up to 56 hours of paid sick leave, right? So even though there's only 3 employees in Utica in this example, because there are over 100 employees in this company across the state, those 3 employees in Utica are going to get 56 hours of paid sick leave, just like the employees in Syracuse and Buffalo would as well. So if you have multiple locations across the state, they're all going to count towards employer size. So that was good to get that confirmed. Then I'm going to go through and talk about what I've been dubbing the big 3. For those of you that have been on these webinars before, you know that I'm talking about accrual, carryover, and use. So I'm going to start with accrual because we did get some more information, and I think this is one of the more significant developments for paid sick leave. So employees, as we know, only accrue paid sick leave for hours worked. That hours worked language was in the statute itself. So we've been dealing with that for some time. We didn't really know what hours worked meant. I got a number of questions from you about, does it count on call time? Does it count travel time? Does it count overtime? And so, we did have some ambiguity on that, but the guidance does clarify that hours worked does not include sick leave. So the time that people are on sick leave does not count towards hours worked for purposes of accruing paid sick leave. And the guidance does provide that hours worked may include on-call time, training time, and travel time to the extent that such would be considered hours worked that you would normally, I think, compensate the employee for. That's how you would do the hours worked analysis. And I know I've gotten a number of questions about whether or not overtime counts as hours worked. The statute doesn't address that one way or another, nor does the guidance. But in my personal opinion, I think because you're compensating the employee for the time and they're at work during that time, that would count towards hours worked for purposes of PSL accrual. Then another thing that New York State said in the guidance about accrual is that employers need only grant or allow employees to accrue up to 40 or 56 hours of paid sick leave, depending on the employer size, of course. We know that employers with over 100 employees have to allow the 56. And that is regardless of whether the employee would have accrued more leave than that using the 1 hour accrued for every 30 hours worked method. So I'm going to do an example of that on the next slide because I think that's the easiest way to demonstrate this principle. So if we have employee A who works for a company with 70 employees, employee A works 35 hours a week and accrues paid sick leave at the statutory rate of 1 hour for every 30 hours worked. If employee A works 52 weeks at this rate, he will accrue over 60 hours of leave. So if you just let his accruals continue, he's going to get up to over 60 hours of leave. But because employee A works for a company with fewer than 100 employees, the guidance allows the employer, his employer, to cap his leave for the year when he reaches 40 hours. So when he reaches 40 hours, he doesn't have to keep accruing if the employer is using the 1/30 rate to accrue the leave. So even though he might have continued to accrue leave, if we just continue to let the year run, we don't have to actually let that happen, and we can cap it at 40 hours. And of course, that would be 56 hours if employee A's company had over 100 employees. So I think that's a bit of a change for employers. That's a bit of a clarification. We weren't sure if accruals had to run continuously or if they could be capped, and this guidance does allow them to be capped based on employer size. Then we talk about another part of accrual, or sort of like accrual, which is front loading. As we know, under paid sick leave, an employer can allow an employee to accrue at the rate of 1 hour for every 30 hours worked, or an employer can front load the leave. And the statute provides that as an employer, you can either front load for your full-time employees the 40 or the 56 hours, depending on employer size. Now, one of the bigger questions, and one of the more common questions that we've been receiving is, well, what if we want to front load for our part-time employees? How do we handle that? And the statute, as you know, didn't really speak to that question. You know, how do we calculate how many hours to front load for a part-time employee? So the guidance does get into that, and it says employers may front load paid sick leave for a part-time employee based on the hours the employee is anticipated to work in the upcoming year at an amount that equals at least the amount the employee would have received if the employee was granted 1 hour of leave for every 30 hours worked. So that that's a little confusing, right? I mean, that's not the most straightforward language, but we're going to do a couple of examples and hopefully that'll make things clear. But basically it's saying if you have a part-time employee, you can front load leave for them, but you have to make sure that whatever you front load is equivalent to what they would have earned if they were doing the 1 hour for every 30 hours worked accrual method. So basically you got to look at how much you were going to expect them to work, kind of calculate backwards, and that's what you would give them at the beginning of the year that you're using for paid sick leave purposes. Perhaps acknowledging that this might be difficult for some employers to keep track of or to track precisely how much leave to front load at the beginning of a year. The statute does say that unless an employer front loads all 40 or 56 hours of the leave for a part-time employee at the beginning of the year, the employer needs to continue to track the leave that the employee uses and would have accrued even though the leave is front-loaded. So again, we're going to do a couple of examples on that. So, and the statute does say that employers must continue to track an employee's hours so that the employer can allow the employee to accrue leave if the employee works more hours than initially anticipated by the employer. So I know that that's a little bit confusing. So hopefully these examples, I tried to make a couple that went with a few different versions of how this could play out for front loading for part-time employees. So for example 1, ABC Inc. has 70 employees. Employee A is regularly scheduled to work 10 hours per week, so a very part-time employee. ABC front loads 40 hours of leave to employee A on January 1, 2021. In this case, because their employer has front loaded all of the paid sick leave that this person would possibly be entitled to, the 40 hours, because it's a 70-person company, ABC Inc. does not have to track employee A's hours or grant her more leave during 2021, regardless of the amount of hours she ends up working during the year. That's because you've already front-loaded her the maximum of what she could accrue, no matter how many hours she ends up working or not working. So in that case, specifically, you don't have to track the leave. Now, this is a little bit different. Let's assume employee B is regularly scheduled to work 10 hours per week. ABC Inc. only front loads 20 hours of leave to employee B on January 1, 2021. So instead of front loading the full 40, they say, no, you're a very part-time employee. We're not going to front load the full 40. We're only going to front load 20 because you're working less than half the week. Assuming employee B's schedule is constant and employee B truly does only work 10 hours a week throughout the year, she would only have earned approximately 17 and a half hours at the 1 hour for every 30 hours worked. So really that 20 hours should be more than enough, assuming that employee B's schedule stays constant at the 10 hours per week. However, even though that 20 hours should be more than enough, it's still the case that ABC Inc., the employer, must track employee B's hours. And if employee B does exceed the more than 10 hours a week or the 520 hours worked, they must allow employee B to accrue leave at a rate of 1 hour for every 30 hours worked until the total accrual equals 40 hours. And then finally, employee C this is, I think, the most complicated example where we have someone who is working 10 hours a week. So that's employee C, but then her schedule changes. So if we have employee C who starts off with 10 hours a week, just like employee A and employee B, and ABC Inc. front loads 20 hours of leave to employee C, just like they did for employee B, we know that they're still going to have to track the hours because they're front loading less than the full 40. But then let's say on June 1, employee C's schedule changes and she must work 35 hours a week as opposed to 10 hours a week for the rest of the year. So at that time, employee C's, as of January 1, she would have accrued approximately 7.5 hours of PSL at the 1 hour for every 30 hours worked. But when she hits 20 hours a few months later, she needs to start allowing the employer needs to start allowing her to accrue paid sick leave at a rate of 1 hour for every 30 hours worked until she hits 40 hours. So that can be confusing with the math, right? But what it essentially means is that's fine if you front load her the 20 hours, as long as you're tracking her leave so that when she starts to work more hours, at which point you are able to get her to add to her bank. And then out-of-state employees, I'm going to talk about briefly. So there's been a lot of questions about whether out-of-state employees should be counted towards calculating employer size in order to determine the amount of paid sick leave the employer must offer. We still don't have an answer to that. What the guidance does say is that out-of-state employees who commute to New York State are only covered for hours when they are physically working in New York. And importantly, this appears to apply even if the employer is physically located outside of New York State. And then with carryover, carryover, and I think Carrie's going to pitch in and say a couple things about this too, because we were just talking about this before the webinar started. So carryover, I know, has been a question that a lot of people have had. How much leave do we have to allow employees to carry over? The guidance and the statute says that employers must allow employees to carry over any unused available paid sick leave. And we know from the guidance that employees must carry over leave even if it could lead to the employees having a leave bank greater than 40 or 56 hours. And we also know from the guidance in the statute that the employer may limit use to 40 or 56 hours per year. Where this becomes, I think, particularly confusing is if you're considering the case of a front-loaded employee where you're giving them the 40 or 56 hours at the beginning of the year. Do you have to still let them carry over any unused leave from the prior year? Now, the guidance appears to be somewhat internally contradictory on this point. There is language that suggests that you would not have to allow them to use the accrued sick leave, to carry over their accrued sick leave that was unused if you front load. And then there's also language to suggest that you would have to do that. So I think that's a bit of kind of a contradiction in terms within the guidance itself. So I urge you, if this is a situation that you're concerned about or questions about, to really work through that and consult with counsel on that issue of carryover, at least until we get more information.
Yeah, unfortunately, like Teresa said, that is a pretty complicated issue, unnecessarily complicated, right? Because I think we can all agree that if an employee is front loaded the full 40 or 56 hours on January 1, and you can limit use to 40 or 56 hours, what's the point in carrying it over? But there is this inherent conflict. And, again, since it is kind of confusing, we'd encourage you to reach out if you want to talk through any specific issues. And, also hopefully, fingers crossed, we get some additional guidance or regulations addressing this.
Yeah, absolutely. We're always hoping for more information. And then on use, the last of the big three. So we know that the statute had set forth a number of reasons for which employees can use paid sick leave. The guidance doesn't change any of those. It just says explicitly that paid sick leave can be used for routine medical and dental appointments. That's regardless of whether the employee has a medical condition or has a diagnosis. You can use paid sick leave for routine appointments. The guidance does go out of its way to say that employers don't have to allow employees to use paid sick leave for bereavement purposes. I think that probably was pretty self-explanatory beforehand, but the guidance does say that for sure. At this point, you don't have to allow your employees to use paid sick leave for bereavement. And the guidance does say, because obviously we're in the middle of the COVID pandemic, paid sick leave may be available in public health emergencies, but that depends on the nature of the emergency. The guidance doesn't specifically state whether paid sick leave is this paid sick leave is available for COVID-19 purposes or not. And at this point, I'm going to turn it over to Carrie to talk about some more aspects of the guidance.
Thanks, Teresa. So we're going to talk about telecommuting. The guidance does mention that employers can't require an employee. So an employee wants to take paid sick leave. We don't want to let them take paid sick leave to suggest, hey, why don't you just work from home for the day rather than taking paid sick leave? Employers cannot do that. You have to allow employees to use paid sick leave. However, right, you can always offer it as an option. But if you do offer it as an option, be careful because you can't then take time away from their paid sick leave bank. If you're offering it as an option, you have to allow that, allow them to use it and not, allow them to work from home and not use their paid sick leave. Just advance the slide here. The rate of pay. We were hoping that the guidance defined what regular rate meant for, purposes of pay. Unfortunately, the guidance doesn't include anything on regular rate. It's not defined. Could include shift differentials, non-discretionary bonuses. It does say, though, that you're not required to pay an overtime rate, which I think most of us, figured, right? I mean, it's, because overtime's not included in this calculation, you don't have to pay paid sick leave at an overtime rate. Let's see, switch to the next slide here. And I'm just trying to, somehow my screen, I lost my full screen here. Just hold on for 1 second. Sorry about this. Well, I got the chat feature taking up my screen. Let me just try to close out of that so I can see the full screen.
Carrie, I can jump in if you want to take it.
I got it. Thanks. Yeah, no, for some reason I lost my screen. Okay, so on the regular rate of pay, the other thing that we, learned about is that employees accrue time, again, based on what they're the actual length of time they're spent working. So if they're commission, flat rate, or non-hourly, you're going to pay them, or calculate their rate of pay based on the length of time that they spend working. You don't have to include tips or gratuities in the regular rate calculation as long as the employee, is paid at least the minimum wage rate or the regular rate, whichever is higher. And Teresa, can you see, I know there's something else on the bottom of that slide, but I can't see it here. Is there another point? Oh, you're muted, Teresa. Technical.
Carrie and I are fantastic at the technology.
Sorry about
that. As
you
can see. So it says, employees who are paid at more than one rate of pay must be paid for leave under the law at a weighted average of those rates. So that makes sense, right? So if you have someone that's paid at different rates of pay, you need to weight those to get the regular rate. I think that's consistent with how you've calculated regular rate in the past.
Perfect. Thanks, Teresa. I got it. I finally got it to work. So we're back. Could we flip to the next slide, please? Okay. I don't want to mess this up again by putting anything into the comments. So in terms of other leave laws, the guidance does make clear that you can elect as an employer to allow employees to use their paid sick leave concurrent with paid family leave. You just can't require it. So if you elect to allow it and the employee elects to do it, that's all fine, and you can allow them to supplement. So they take their $840 PFL weekly wage payment, supplement some paid sick leave, run it at the same time. However, you just can't allow them to receive more than 100% of their wages. They can't go over 100%. Employers, the guidance also talks about Westchester County has a paid sick leave law for domestic employees, and employers have to grant both the county leave and the state paid sick leave. Again, we also, note that the guidance says that paid sick leave can't be read in a way as to interfere with federal law. So, we wanted to call special attention to that as well. Could we please move to the new slide? Thank you. Record keeping. So you have to keep records for 6 years, payroll records, and the records now have to include the amount of sick leave that's been accrued and used by each employee on a weekly basis. So significant record keeping obligations here. And then we all knew, because the law made this clear, that upon request by an employee, employers are required to provide a summary within 3 business days of the amount of sick leave used and accrued in that current calendar year and in the previous calendar year. Next slide, please. Thank you. In terms of notice and policies, employees only have to provide written notice prior to the use of paid sick leave. Unfortunately, we don't have any guidance to say how far in advance must they notify an employer, which it's problematic for employers for a lot of reasons. But as long as employees are providing notice, and the notice is in advance of their use of paid sick leave, that's sufficient. Now, the guidance also mandates that employers provide employees with either a policy or posting regarding paid sick leave. So what the guidance essentially says is that if you're going to have any limitations, like a maximum amount of time, which I think most employers are going to have these limitations, right? You accrue up to 40 or 56 hours per year. There's certain increments where you can use the leave if you're going to allow leave in 4-hour increments, or any lesser amount if you're going to allow it in 1, 2, 3-hour increments. You have to put that in writing, and you have to have that in your policy so that employees have noticed that these are your limitations, and the guidance requires that these be put in writing. Next slide, please. I'm trying to rush through this here. I know we're coming close up here on time. Some miscellaneous things that we wanted to point out or call your attention to. Employers cannot impose a waiting period for either the use or accrual of paid sick leave. So you can't have a policy that says new hires, can start accruing on day 1, but they have to wait 90 days or 120 days to use paid sick leave. We can't do that. Seasonal employees, this was actually interesting. The guidance states that seasonal employees who maintain an ongoing relationship with their employer have to maintain the employers have to maintain their leave accruals during such breaks in employment. So, what exactly does that mean, I think, is our question, right? It's clear that if it's a seasonal employee and it's an ongoing seasonal relationship, you have to, carry over the leave balances during the breaks. Employers are allowed to have a policy that allows employees to donate their leave to other employees, as long as it's voluntary. So you can elect to do that. The guidance also does say that employers can discipline employees for using sick leave. I think you have to be very careful about this, right? Because you can discipline somebody for using sick leave improperly or for fraudulently using it if they're lying to you. What I think is, the real dilemma here is that how are employers supposed to know that employees, how can we find out essentially if we're not allowed to ask for any documentation to justify or substantiate the reason that employees are taking the leave, how do we know that they're using it fraudulently? But if you do find out somehow, not by asking for documentation, but by some other means that they're using it fraudulently, you can discipline them for that. Next slide, please. In terms of penalties, the guidance makes clear that failure to provide paid sick leave is the equivalent of a failure to pay wages. So all of those, penalties come into play. So you would be subject to civil lawsuits, administrative or criminal penalties, which could include an order to pay the wages, 100% liquidated damages, or civil penalties in an amount double. And we have to be careful here because I think the concern is that these claims are brought on a class basis. If you have a policy or you're improperly providing sick leave, we obviously want to watch out for class-based claims. Next slide, please. In terms of unanswered questions, so we threw all of this at you really quickly. I think the bottom line is there are a ton of unanswered questions. The guidance was not particularly as helpful as we wanted it to be. We were hoping for a lot of these questions to be answered, but they weren't. So again, how the regular rate is calculated, that was not answered. How do employers count the number of employees for purposes of whether to provide 40 or 56 hours? I think Teresa mentioned that earlier. That has not been answered. We cannot, can we require documentation? As of now, that has not been answered. So, you can't do it. How do employers incorporate paid sick leave into existing collective bargaining agreements? That's essentially the same. There are some issues I think that, came to light through the guidance, but, they're somewhat complicated. So feel free to reach out, if you want to discuss those with, an attorney. Does the employer have to track PTO used for paid sick leave purposes when the policies are combined? I saw a few questions come through on that. Unfortunately, that wasn't answered. So you have a PTO policy that, allows employees to, accrue far more time than is allowed under paid sick leave. But do you have to track it, or can the employee just call in and say, I'm using PTO? And as long as you've given a sufficient amount of time, if they use it all for vacation, does it matter? I'm inclined to say it doesn't, but I think it's still a bit of an open question. How to calculate accruals for exempt employees. We were really hoping that this guidance said, like New York City's does and some other paid sick leave laws, that you can assume that exempt employees work a 40-hour work week. Unfortunately, again, that was not stated. So, it's not as safe to assume that they work a 40-hour work week as we'd like. And the last question here, again, got cut off here, Teresa. Oh, here it is. Can employees use PTO prior to January 1, 2021, when PTO and paid sick leave are combined? Again, unanswered. Let's just move to the next slide quickly. What we tried to do, I know it's 12:30. We'll try to answer these really quick. We figured there were a lot of you on the line, so we tried to collect questions in advance in the hopes that we could, take the most frequently asked questions and give you some answers. So the first one, if an employee is out for 3 days for a paid sick leave qualifying reason, but doesn't want to use the leave, can we force them to use it? And again, the statute isn't clear. There's nothing in the guidance on this. I think you can certainly say that if they don't use their paid sick leave time, you're going to treat it in accordance with your attendance policies, and that it's unauthorized. You could probably force it. Again, it's not entirely clear. You certainly cannot force it if it's running concurrent with paid family leave or FMLA running concurrent with disability, right? So there's certain times when you can't force it. I would just be careful there. Feel free to reach out. We can walk through all of those issues with you. Teresa, do you want to answer the second one? Can the employer pay out paid sick leave at the end of the year instead of carrying it over?
Sure. So this is a question I know a lot of you have payout policies. They're voluntary or involuntary. Unfortunately, neither the statute nor the guidance talks about this, and they seem to, in fact, kind of disfavor it by saying that employees must be able to carry over their accrued unused paid sick leave or available unused paid sick leave. I think it would have been very easy for them to put in an FAQ or something about payout. They just did not do that. So we're still kind of waiting on that. And then Carrie, does New York paid sick leave run concurrently with New York City earned sick and safe time?
Yeah, so if you're an employer that's covered by both, you have employees working in New York City, you just have to make sure, I mean, New York City just recently amended their law so that it's in line with New York State's paid sick leave law, but there are still some differences. So I think you can run it together, but you just need to ensure that your policy covers both and that you're satisfying the use, the carryover, the accrual requirements of both laws. Teresa, last one, how do we make paid sick leave work with our attendance policies?
So one of the things you're going to want to make sure is that you're not disciplining employees for using paid sick leave appropriately. I see a number of attendance policies when I review handbooks and otherwise that definitely need to have that language put in there explicitly so that employees aren't getting an adverse impact when they use paid sick leave under the attendance policy. So just be careful of that. And then Carrie, last one for you. Can employees be prohibited from using paid sick leave after they've given notice to resign?
Yeah, and that's an easy one. Unfortunately, they can't, right? I know some employers do that with PTO or vacation. You cannot prohibit an employee from using paid sick leave, even if they've given you notice to resign. That's their time. And if they're sick, unfortunately, you have to allow them to use it. And then can we just move to the next slide real quick? It's kind of a conclusion, some recommendations. So obviously, again, I think this continues to evolve. I think we're going to continue to learn and get more information. I've heard, and don't quote me on this, but, I think we're probably going to get some regulations on paid sick leave with a notice and comment period. So, I think we're waiting, still in the hopes that we get those regulations. So for now, I think you review your policies, you update them. We try to work out some of these issues. And again, hopefully, some of the issues are clarified if we do get some regulations issued here before January 1. Make sure, though, that you're still tracking your hours for non-exempt employees. And, make sure you're preserving records because the accrual, if you are going to accrue instead of front load at 1 hour for every 30, that started on September 30th. So for use on January 1. So you're okay now in the sense that employees can't use that time, but we have to make sure that we're tracking it so that we can credit them with that time on January 1 for use. Otherwise, I thank you for joining us. I'm sorry we couldn't answer all your questions. Unfortunately, we just don't have those answers right now, but we hope that this was helpful. Feel free to reach out to either Teresa or myself if you have additional questions. And I'm sure we'll be presenting on this in the future. Thanks.
Thank you, everyone.